The Arizona eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Arizona. The non-payment notice. If the tenant fails to pay rent due, the landlord is required to give a notice to either pay or quit, giving them no less than 5 days before terminating the lease. The non-compliance notice. If the tenant violates other terms of the lease, it can be terminated in 10 days after delivery of the notice if the violation is not remedied. In the event of material health or safety violation, the landlord should send a 5-day notice to the tenant. However, for tenants committing illegal actions, the Arizona law doesn't specify the notice period. What if the tenant fails to comply? If the tenant fails to pay rent due and associated fees or remedy the violation, the landlord can file an eviction lawsuit with an Arizona justice or superior court, depending on the value of property damage or rent unpaid. The filing fee is either $35 or $218, depending on the chosen court. Then, the summons and complaint must be served on the tenant by the court at least 2 days prior to the eviction hearing. In the state of Arizona, the tenant is not required to file an answer with the court, but failure of the tenant to appear for the hearing or the judge's ruling in the landlord's favor will result in the issue of a writ of restitution. According to this document, the tenant might have to move out immediately after the constable or sheriff receives the writ. However, the court may order to delay the eviction in rare cases.